On this morning's Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine.
All right, let's get to it. And this first case, we're going to head to the state of Texas. And I like how you described this first case as far as the tweet is concerned, a fence of convenience. This involves a landowner's son who managed for his father, and his father lived in Florida.
Well, actually, fence of convenience would be the second item. The Florida one, yeah, it's a Texas case. The landowner did live in Florida. His son was operating the farm/ranch down in Texas, and they would occasionally need hay cut. And so they had a neighbor, and the neighbor had cattle, and they would allow the neighbor to come and cut hay, and the payment would basically be, we're going to take some of the hay that'll serve as the payment for this, and then for your services, you can take the balance. So they said, we need some, you can have the balance, and that's how you get paid. Well, this neighbor figured out that he thought he could get some of the FSA payments associated with that land. So he drafted a document, and it basically, all it said was, I have a lease for the next 5 years on this property. And he got the son to sign it. He takes it to the FSA office, the county FSA office, just to document that he's got a lease and they're sharing the hay off the ground. So therefore, they should be sharing the FSA payments. And FSA didn't check on that, and they just started paying him the payments. Well, the landowner, the father of the son who was managing it, but was living down in Florida, gets approached to lease out the ground for solar panels. And it's a lot more than he can make with this hay arrangement he's got with his neighbor. And so he enters into this agreement with the solar company, and they tell the son then tells the neighbors, well, we don't need hay cut this next year. Probably, we'll just contact you if we ever need hay cut again. And that fellow said, well, I've got a lease, and you can't do this to me. And they end up in court on this.
And with the appellate court agreeing as well, in some aspects, it's whatever you do, make sure it is done properly in the aspect of forms or anything that you have that you're doing with that too.
Yeah, exactly. The interesting thing is, Greg, the trial court actually ruled for the neighbor and said, okay, yeah, that's the form that was submitted to the FSA office was sufficient to show that you actually did have a lease agreement. It goes to the Court of Appeals, and the Court of Appeals said, no. We don't have anything that can satisfy the writing requirement for a lease. The document didn't contain any essential terms of the lease. It didn't denote even the names of the parties. It didn't describe the property. It didn't note the rental rate. It just said, we're going to share some hay off of this. And it didn't list any conditions. It didn't list any consideration that was given for this purported lease. And so there was no lease agreement at all. And the appellate court reversed the trial court's judgment. Now, another issue that's kind of lurking behind the scenes here was this guy was trying to game the payment limitation system. And FSA just took this document and started sorting out the payments in accordance with this document, didn't do any checking. That's also the troubling aspect of this, that, of course, that wasn't before the court. The court didn't get into that. But, my goodness, that's incredibly sloppy. So we've got to be careful. You're right. We have to be careful on these agreements that are put together. If it truly is a lease, take the time to formalize a true lease agreement and then try to not to game the payment limitation system.
Now, and my apologies for the first thing, because you're right. The second topic of discussion is the fence of convenience, and this is land that's possessed by someone that knows possession violates the ownership's rights of someone else, and this goes to what is termed as adverse possession can come into play.
Right, and what you said there is the key to adverse possession. Adverse possession is a knowing violation of somebody else's true right. And so there has to be knowledge that a fence that is being used is not in the right location. And so the owner of the land, actually both adjacent parties, know that fence is in the wrong place, or they're farming in an area where they shouldn't be farming, and one party allows it, the other party continues to do it, the one party doesn't say anything. But the point of adverse possession is you know where the actual boundary is. Fence or not, we know where the boundary is, and one party is willingly violating that, and the other party is allowing it to happen. Now, what we get often in agriculture, Greg, is somebody wants to put a fence in, and it's just on the surveyed boundary, it's just not practical to put the fence there. We just can't do it. We've got very thick brush, we've got ravines, we've got water, we've got high canyons and cliffs, depending on where you're at. And so it just would be a lot easier to put that fence off the line a little bit. And so the parties just kind of agree. That's what we mean by a fence of convenience. It's just convenient to not put it on the line. It would be too costly to put it on the line, but nobody has the land records changed to reflect that new fence, that fence that went in as the actual line. So that becomes a fence of convenience. Well, then can you ever have adverse possession in that situation? Because the parties know where the boundary is. They know that they put a fence that was not on the boundary, and they agreed to that. That's what was going on in this case. And normally, Greg, when we have this situation that arises, we're just talking about a strip of land that might be, 10 or 20 or maybe 50 feet wide and a quarter mile long until we get around whatever it is the obstruction is. This was in Wyoming, and that strip of land, put that in quotes, was 100 acres. So we're talking about a big ranch. We're talking about major obstructions, and they just put a fence up to keep cattle in a particular location because it was just convenient to put a fence there. And then one of the landowners says, after a period of time, well, that land's mine.
And so much of it is that, if it's a fence that, and as you mentioned, not actually on the surveyed property boundary, that may give rise to something like a title action under a couple of situations. But we talked about what was about the first thing about making sure you know what you're doing. In this case, this sounds like it would almost apply to this as well.
Yeah, this fence was presumptively permissive. So what the court said was, well, you can't make an adverse possession claim out in this instance because you had permission. Both parties agreed to put the fence in the location it was. That means the statutory time frame, and that happens to be 15 years in Kansas. It was a shorter time frame in Wyoming. That statutory time frame, it never begins to run. You never toll that time frame because of the permissive use. And so if you have a fence of convenience, you can never have an adverse possession claim in those states where hostility is a requirement in the adverse possession statute. And that's the key point out of this case. And Greg, fence issues create a lot of questions. Outside of tax, I think I've said it before, if I were to guess as to what generates the most questions that I field, once I get past tax, estate planning, business structures, and legacy planning, then it's fences and leases. And this is just another one of those illustrations.
Joining us on the program, Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Laws. We have covered a couple of topics already. Another one, Roger, we want to cover is just recently the Department of Labor released a new rule on calculating H-2A minimum pay rates.
Yeah, Greg, this one was a final rule that was adopted on February 28, and it's going to go into effect on March 30th. And this one is controversial, to say the least, and there's already legislation that's been introduced into the U.S. Senate to block it from taking effect and basically keep the same rule that was in place for 22 in place for 2023. But what we're talking about here is the adverse effect wage rates that you have to pay to an H-2A worker, these non-immigrant foreign workers that farmers will hire just because of a shortage of domestic workers, or let me rephrase that, a shortage of willing domestic workers. that would put in a full week's work. And that's particularly needed during planting time and harvest time. And these rules are pretty onerous because it's going to cause the wage rate that has to be paid to these H-2A workers in non-range occupations. So this would be for all occupations other than herding and production of livestock on the range. So your farm workers in Kansas, anything other than a range worker, these temporary labor workers under the H-2A program are going to get a pay increase. Now, the pay increase in and of itself is not a bad thing. That's beside the point. The problem is, can the small farming operations, the relatively smaller farming operations that operate on very thin margins to begin with, can they handle this? And when you add in this increase, which is going to be, depending on the situation, probably a 5 to 10% wage increase on a per hour basis, the employer, the farmer, will also have to provide housing and utilities. They'll have to provide a vehicle, communication, such as a cell phone or a SIM card line. And they'll have to pay the airline ticket both directions, any agency fees that might apply, plus any workers' compensation insurance. And there's probably more that we could add to that list. And when you add that to the base pay increase rate on an hourly basis, that's going to be a substantial additional burden in 2023. And then you throw in truck drivers. And so if you need heavy truck drivers to work for you, those rates are going to go up. They have to be paid about $24.50 per hour for grain, about $30 for tendering chemical to a sprayer. And you compare that to ag retailers are in the $20 to $23 per hour range for their truck drivers. So the other thing about this, Greg, the farm rate under this rule applies for the time the worker is on the farm. So even if the worker is doing a lower rate job, that higher rate specified by this new rule applies. And all the domestic workers, if the farm has, say, local help, those domestic workers have to be paid this same rate also, while you have H-2A workers there. So this is troubling for a lot of smaller operations that can't easily bear this cost, or as easily bear this cost as a larger farming operation would. And hiring labor is one of the major concerns that farmers have, and it has been for a number of years.
Yeah, absolutely. Correct me if I'm wrong, there is legislation, I think, in the Senate right now that would keep the wage rate at the 2022 levels?
Yeah, there is, and that's bipartisan legislation. I think that's probably got a pretty good shot at passing because there's enough, I think, on both sides of the aisle politically to get that thing through. And you've got, particularly in the House, there still are enough representatives that represent strong ag districts or where ag is sufficient enough that I think you could get pretty strong bipartisan support in the House. And I think it would go through the Senate. So we shall see. That they've got a couple more weeks to get that passed before this takes effect, and I hope they can do that and not have to do it on a retroactive basis, which would just be confusing if they don't get it done on time.
And finally, a discussion about a decision that took place not to review the USDA wetland certification was upheld.
Yeah, Greg, this is an Eighth Circuit case that's going to be argued on Tuesday in the Eighth Circuit. Actually, they're going to have in-person arguments at the University of South Dakota Law School. I'm still trying to figure out whether myself and my law students will be able to watch this online, but the court hasn't announced whether Tuesday's hearing will be available online. This involves an 0.8 of an acre wetland, supposed wetland, on a flat farm field in southeast South Dakota. It doesn't drain into any ditch or water course. What happened was, kind of ironically, the individual's grandfather planted a tree belt, a shelter belt, back in the 1930s to protect the buildings and keep the snow away from the buildings and off of an access road to the farm. And of course, what happens is that snow builds up. Those trees are fully mature. The snow builds up, and then in the spring, it starts to melt. And about half the time, it leaves a puddle, an 1/8 of an acre puddle in the middle of the farm field that he has to drain the excess water off of so that he can plant. Well, USDA came in and said, you've got a wetland, you're violating the swamp buster rules. And he said, now, wait a minute. I'm entitled to review of that. I think you're not looking at all of the data, and you're not evaluating this according to the law the way that you should. I want a recertification of this. And the USDA said, no, we're not going to do that. And, too bad. And he said, well, you're required to do that by statute, which they are. There's a federal law that says once the producer asks for a recertification, you're affected by the first certification, you get an automatic bite at another apple. You get a review. And if you have new evidence, that needs to be taken into account. And he said, well, I have evidence that you didn't look at the first time. I want a recertification. I want you to evaluate this again. USDA didn't do it. He sues. The trial court said, well, that's not mandatory on the USDA. They don't have to. It doesn't violate your due process that they didn't, and you didn't show any independent source of authority that would give you a right to a certification review on request. And so the denial of review by the USDA was not arbitrary or capricious. And he's taken that on to the Eighth Circuit, and we will see on Tuesday how the oral argument goes in this case and whether this goes all the way to the U.S. Supreme Court, depending on what happens in the Eighth Circuit. Now, this, again, is in light of a current wetland definitional case that's currently before the U.S. Supreme Court. That may or may not have bearing on this because WOTUS and swamp buster are two different things, but it really kind of depends on what the U.S. Supreme Court defines as a wetland in that WOTUS case.
Speaking of the Supreme Court and speaking of WOTUS, I think today, correct me if I'm wrong, is the day that the new rules would go into effect for WOTUS, but that's also pending the Sackett v. EPA case as well?
Yeah, you're right. Today is the day, but it's all kind of pending what the U.S. Supreme Court says. So we shall see, and we should see soon what the Supreme Court says in that Sackett case.
All right. And if people, Roger, as always, want to read more about these cases, they can go to your blog or they can come Wednesday to Alma at the Farm Profit Seminar.
Yeah, that's right. They can do that, washburnlaw.edu/Walter, WALTR, or these are some of the things that I'll be talking about Wednesday evening in Alma.
All right, sounds good. Roger, as always, appreciate it. Look forward to seeing you Wednesday.
Thank you, Greg. Same here.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.